This is a case of a education trust versus Commissioner of Income Tax Exemption. Actually, the assessee was a charitable trust, educational, running the education institutions. The trust was involved in providing education and running educational institutions. It applied to the tax authority for approval under Section 80G of the Income Tax Act 1961. This approval allows donors to give money to the trust to claim a tax deductions on their donations. While examining the application, the Commissioner of Income Tax Exemption reviewed the financial records of the trust and noticed that some of the issues are not matching to the trust. The Income Tax Department of India, through the CIT exemption, rejected the application for ATG approval. The authority gave two main reasons for rejecting the request. One, the trust was collecting fees from students for its educational services. School, the trust has earned surplus income during the financial year. According to the department, these facts suggested that the activities of the trust were commercial in nature and not purely charitable. Therefore, the CIT exemption concluded that the trust was not eligible for approval under Section 80G. The trust filed the appeal before the tribunal. The trust was not satisfied with the decision and filed an appeal before the Income Tax Appellate Authority, Bangalore. The trust argued that educational institutions usually collect reasonable fees from students to meet their operating expenses. It also explained that earning surplus income does not mean that trust is working for profit, especially when the surplus is used for the objectives of the trust. The trust further stated that all its activities were genuine and carried out according to the charitable objectives mentioned in the trust deed. It also pointed out that department had not provided any evidence to show that the trust was carrying out non-genuine activities or making personal profit. After examining the fact and hearing the arguments from both the sides, the ITAT made some important observations. The tribunal stated that many educational institutions charges fees to run their operation and this is normal and acceptable practice. It also said that earning surplus income does not automatically mean that the institution is doing business for profit. The tribunal examined that while granting approval under Section 80G, the authorities should only check two things. First, whether the objective of the trust are charitable, and second, whether the activities of the trust are genuine. In this case, the department did not provide any evidence to show that the activities of the trust were not genuine. The Income Tax Appellate Tribunal held that approval under Section 80G cannot be denied just because the trust collects fees or earns surplus income, unless the tax department proves that the activities are not genuine or that the trust is working with a profit motive. The approval cannot be rejected. Therefore, the tribunal allowed the appeal filed by the trust and cancelled the order passed by the CIT exemption. The main principle from this case is that earning surplus income or collecting fees by an educational or charitable trust is not a valid reason to deny approval under Section 80G of the Income Tax 1961 unless the tax authority proves that the activities are not genuine. This is the case heard by the ITAT Bangalore in the year 2026.